The reason I call this case next is because I don't want to lose sight of the point here, Ms. Weezy, that the Voth case is one where Mr. Voth actually was cited for conduct that occurred after the emergency rule, but before the Conley decision. Is that correct?
Yes.
Let me just... So if the rule can only be supported as constitutional if enforced in light of the Conley ruling, if the Conley ruling didn't exist at the time that Mr. Voth was cited, doesn't the state have to agree in this case that the rule is unconstitutional? And even if you disagree with the idea that it's facially unconstitutional, in light of your argument, doesn't it just logically follow that it's got to be unconstitutional as applied to Mr. Voth because he doesn't have the benefit of that qualification that the Conley ruling supplied?
It's the position of the state that the Conley decision was not a final decision and that it was not determined whether or not that rule was constitutional or unconstitutional without further evidentiary proceedings.
Well, Judge Conley, of course, we've been through this, determined it was either, at one point he says flatly unconstitutional, fairly strong likelihood of being unconstitutional, strong likelihood of being unconstitutional, and you've urged me to follow that in the other cases, and you've said that that's the only way that this is saved from being unconstitutional. It just seems to me to follow that without the benefit of that, even the state would have to concede that it's unconstitutional as applied to Mr. Voth. Is there something I'm missing about that?
No, Your Honor, it's the position of the state that that was not a final decision, but as applied to the cases after the decision, that the state acted in compliance with the injunction.
Mr. Bach, you basically join in the argument that was presented by Mr. Olson, and you also have an argument that under the 14th Amendment, the rule did not provide fair notice and was vague as to Mr. Voth, particularly insofar as the words conduct and event are concerned.
That's correct, Your Honor.
Okay, so Mr. Voth is actually cited under subsection V and not VM, dealing with conducting the event.
Right.
Okay. And Ms. Weezy, was it the state's intent to, I know you've asked to amend all the other citations to charge a VM violation, which has to do with participating in an event versus actually conducting one. I guess I'm maybe just more curious than anything, but is there some reason that would help me understand the state's position here that you've not asked to amend the Voth citation?
It's because it's in a different posture. It is in a pre-Kissick injunction posture.
Okay. Well, what do you want me to do with that, given that Judge Conley reached the decision that he reached? We all agree this was in a pre-Kissick posture, as you say, but what does that mean? Does that make the application of this rule constitutional as to Mr. Voth, where it wouldn't have been as to the others according to your position because they followed the Conley ruling?
As requested in the state's written submission, it's the state's position that it does need to be determined whether or not that is constitutional based upon further evidentiary proceedings.
If I follow, there were evidentiary proceedings in Kissick case.
Yes.
Okay. And do you remember, this goes back a couple months now, but when we were first here on this whole scheduling of these constitutional issues, I asked you whether you were requesting that we have an evidentiary hearing or whether I could simply accept as true for purposes of deciding these motions the facts as found by Judge Conley. And I believe you told me at that time I could accept those facts as true for purposes of these motions. Am I wrong about that?
No, I think you're right. I think that I had not reviewed the Mr. Both's motion at that point.
Okay. So are you really asking that we have an evidentiary hearing to effectively repeat what was done in the federal court?
It's the state's position that what is requested in the written submissions, yes.
If I were to take evidence on this, what would the state, by offer of proof, present at that hearing that was not in front of Judge Conley?
I suppose it would be further testimony from administrative and law enforcement officials.
Okay, but what would they tell